Am I there? Okay, right. And then it did something funky. So I just want to know, I'm assuming we're live now? And then it says Lauren posted. I've been on for about 30 seconds, but I don't see if anyone's here. Okay. Okay, so you can hear me? And how do I know when someone is on? Because I don't see you. Like, so how do I know when people are on? Got it. And hi, everybody. I'm gonna hang. I'll hang up the phone, Janice, because I think people are here. Thanks. Hi, everyone. Welcome to our Enea, Scanlan, Sirignano Facebook Live program on healthcare proxies and powers of attorney for your college-age children. We'll just wait a couple of minutes for other people to log on. My apologies in the beginning for any technical difficulties. If you have any questions, please feel free to type them in, and we'll answer them either throughout the program or towards the end. Welcome to all of you who are there. I will try to have the camera. This is my first time doing this, so thank you all for your patience. I'll try to have the camera pointed in a good direction the entire time. So we're going to be talking about, again, powers of attorney and healthcare proxies for our college age or any child or any person over the age of 18. I started thinking about doing this topic because one of my daughters actually said to me within the past couple of weeks, as we've all been having a lot of family time together, you know, Mom, you're done raising us. And I looked at her and said, I might be done raising you, but I'm not done parenting you. Because just because someone is over the age of 18, doesn't mean they still don't need parenting. But when they are over 18, we no longer can legally make either medical or financial decisions for them. And my oldest daughter, who's now almost 20, she's in college. And when she turned 18, her senior year of high school, in fact, for her 18th birthday, she had the privilege of coming to my office and signing both a power of attorney and a healthcare proxy. My friends made fun of me. Her friends made fun of her. But when people ask me what the most important legal document is, I always tell them that there are actually two, both a power of attorney and a healthcare proxy. And what are those documents? A healthcare proxy is a document that states who is to make medical decisions for you if you're unable to. So, for example, my oldest daughter, who's almost 20, her healthcare proxy appoints one of her parents. I drafted the document, frankly, it's me, to make medical decisions for her. And if she's not able to, her dad, my husband, makes those decisions for her. And again, it's always important. She was abroad last year for a gap year before college. She had to go see a doctor where she was. And in order for me to actually be able to speak to her doctor here and provide anybody, medical staff, any medical records, I actually had to use that healthcare proxy to show that I was a designated agent for her. She also has a power of attorney form. A power of attorney is a document that says if you're unable to handle your financial affairs, that you're appointing somebody to make those financial decisions for you as well. And it could be as simple as if they're traveling abroad or in college in another state and they get a check in the mail to be able to deposit those. Over 18, they might have summer jobs or a job in school and may have to file a tax return. In order to be able to file, to sign any tax returns, handle any banking for them that they can't do on their own, we actually at this point need their authority, their legal authority to do so. And frankly, in this day and age where we're all, many of us are working from home, our children are working from home, are learning from home, Again, it's so important to start having these conversations with our kids who are over the age of 18 in terms of what their wishes are, who should be making medical decisions if they're unable to. And it can be as simple as actually accessing medical records. A nephew of mine, I did a healthcare proxy for not that long ago because he had to have surgery. He was in another state. His parent needed to access medical records here. Again, because once our child is over the age of 18, they still need to provide us with that permission in order to deal with their medical information, their financial information as well. Again, we can't do their banking for them anymore without their legal authority to do so. We can still, again, as I said earlier when we started talking about parenting them and helping them make decisions for themselves, both big and little, as parents are wont to do. But again, it's just so important to be able to have somebody to legally be able to make those financial and medical decisions when one is unable to do so. In terms of signing documents, so it's very interesting. As we all see, Governor Cuomo has been at the fore these past couple of weeks now in terms of the coronavirus. But he's also been doing a lot of work with the legal community in terms of requirements for for witnessing documents and notarizing documents. So a healthcare proxy, what it does is it appoints an agent to make medical decisions for you. There can only be one agent appointed at a time. So I Sara, appoint Kenny to make medical decisions for me. If Kenny is unable to, Kenny's actually my husband, I appoint, Gabrielle, who's one of my children. I cannot have two agents acting together. There has to be a chain of command in terms of who's going to be the person making those medical decisions for me. That document does not need to be notarized. A healthcare proxy just needs to be witnessed by two individuals. A person that you're appointing to make those decisions for you, the agent is not allowed to be a witness to the signing of the healthcare proxy. So again, it's very important to note to have witnesses who are separate than the individuals you are choosing to act as your agents. A power of attorney as well. A power of attorney has to have both witnesses as well as a notary. So as I was talking about Governor Cuomo before, there is an order that now allows for remote notarization. So in non-COVID-19, non-coronavirus times, in order for me as an attorney to notarize a document for someone, I have to see that person in person. And I have to ask certain questions. And again, I have to be in person in order to notarize something. The governor for right now is allowing something called a remote notarization, wherein I can be on Zoom, on Skype, on WhatsApp, any type of video, watching that person sign. I can then notarize that document, the copy of the document that I have. And the notary statement, instead of saying I witnessed you in person, it can be modified for right now, stating it was a remote notarization. Again, please feel free to post any questions that you might have or any comments, and I'd be happy to answer them throughout the presentation and before we sign off. So the power of attorney is a little more complicated because we do need two witnesses for it, as well as a notary. But what does a power of attorney allow someone to do? So if I have a bank account that's in my name alone and I'm unable to handle my financial affairs, the agent under that power of attorney with that form is authorized then to make those financial decisions. And what type of financial decisions can that person make? So the statutory power of attorney allows someone to help with banking, real estate, stocks and bonds, taxes, and pretty much standing in the feet of that person, of the principal, can handle the financial affairs. Our power of attorney, we actually add some modifications to it to allow the handling of digital assets, because people in this day and age have online bank accounts from the online banks, not only brick and mortar banks, to be able to give access to those digital assets as well. The power of attorney also has something called the statutory gifts rider. The only way a person can make gifts of the principal's assets is if the principal signs the second part of the power of attorney, known as the statutory gifts rider, which then allows the agent to make gifts of that person's assets, which are in that person's best interest. For our clients for whom we're doing elder law and estate planning, we almost always recommend that they have the statutory gifts rider added to the power of attorney. For our younger clients, especially our 18 and up and 20 somethings, we usually don't recommend a statutory gifts rider because at that point, please God, they're not doing significant Medicaid planning, if any. And again, most of the 20 somethings don't really want their assets to be able to be gifted to someone else if they do need them for their care. But again, it becomes a very individualized question, and each person really decides things differently. I see just someone said she's having a hard time getting into the presentation. I hope that issue has been resolved. I believe this is being recorded as well, and we can send you a link to the recording when we are done here this afternoon. And I always think it's very important when our children turn 18 and are 20 somethings, either when they're living close to home or across the country, to start having those grown-up type conversations in terms of the importance of estate planning. I have a number of nieces and nephews who are getting married, just got married, or new parents. And I always tell them that, now that they've entered this phase of life, it is so important to make sure they have their appropriate estate planning documents, especially if they want their spouse at this point, instead of a parent being able to making medical decisions for them, appointing a guardian if they have a young child, making sure a guardian is appointed for that child as well in their estate planning. And also to make sure those conversations are being had with their children in terms of, and again, now that you're over the age of 18, your parents, we can't just make decisions for you. And it's important to also express what your wishes are in terms of medical care, medical treatment, who should be making those decisions, what type of decisions would you want a parent or somebody else to be making for you. I think I have a question here in terms of where this is, in terms of where the program is happening. We are on the Enea, Scanlan, Sirignano website. And I believe some of the questions, someone actually just texted me a question, so I will check that as well. Good. Everybody, I was told there was an issue, but we can see or hear you. And if you're watching it on your phone, you do need to scroll on it just a bit. So again, and as I said, I do estate planning, Medicaid planning, and elder law, trust and estates, Medicaid planning, elder law planning. We always normally talk to our clients who are in their 40s and 50s about really talking to their parents, and older parents really talking to their children about what their wishes are, about what their needs are, what they want to do in terms of end of life, which child or which family member they want making financial and medical decisions. But it's also, I believe, so important to start these conversations when our children are younger. As an elder law, trust and estates attorney, my kids, it's part of dinner table conversation. They know about the important estate planning documents. They know about Medicaid planning. For many of you, depending on your profession, your children are probably experts in those. But again, it's so important, as my kids know, to have these conversations starting young, to make sure that children know what parents' plans are, and vice versa, parents making sure, because we are still parenting, even though we are not raising them anymore, parenting to make sure that it's important that the children know that they have to have these important legal documents as well. And also it's important for them to be able to articulate their wishes as well. So again, these are all very important conversations to have. And it's interesting, I was speaking to my dad before starting this today, and he always jokes that, he has everything taken care of. My siblings and I, we don't need to worry. But I said to him, so Dad, just God forbid, where are these documents? What are your wishes? We don't need to be looking at anything, but it's just important to know where the documents are, who should be making decisions. God forbid decisions need to be made. I'm just looking to see, I think we have some questions here. And most of those are, the one question here is, how do you start the conversation, either with a parent or a child, about the importance of estate planning documents? And I think it's important, goes to when speaking to our college age children, we talk to them before we send them off to school about the importance of studying and being safe and making smart decisions. This is part of that conversation, right? In terms of having our affairs in order and making sure that the same way they're getting ready for school, they're buying their textbooks, paying tuition, choosing a roommate, that they have their estate planning, their advanced directives, which are the power of attorney and healthcare proxy, in order as well. Because again, that's part of becoming a grown-up. Being a grown-up is knowing that at this time they have to make decisions. They can make decisions for themselves, but also if they can't, who they're going to turn to make those decisions for them. And so in terms of a power of attorney, we talked a little bit earlier that the power of attorney is a document that says if a person can't handle their financial affairs, they're appointing somebody to do that for them. And I talked about banking, and someone needs a checks deposited into an account. Again, you could do that if the person is over 18, we can't handle our child's finances or banking anymore, but we can deposit those checks for them as the agent under the power of attorney. But it's also important to note, and one of the other important reasons it's to have that power of attorney is to be able to access funds if that account is in that child's name alone. Let's say your child is traveling abroad and doesn't have enough cash or isn't able to access his bank account, for us to be able to do that for them. So there are always misconceptions, and people think, well, that person's my child, that person's my spouse, I can access those assets for them. But if there's an account in a person's name alone, only the account owner is able to handle and able to access that account. So for example, if your child has a bank account in her name alone, once they're over the age of 18, we can't go into that account and help them with their banking or access those funds without their permission. If there was a joint account, let's say my daughter and I had a joint bank account together, that was her funds. Because it's a joint account, I still have the ability to access those funds because I'm a listed owner on that account. So again, when there are assets in a person's name alone, and that person is unable to handle his or her financial affairs, without that power of attorney document, a person then has no legal authority to be able to access those assets. Again, so it's very important as we get older, as our children get older, to be able to discuss with them the importance of those legal documents, the importance of authority to access those documents and access financial records, and also the ability to assist or make medical decisions when someone over the age of 18 is unable to do that for themselves. So questions come up a lot in terms of what happens if my child is over the age of 18, but she has a mental disability, so is unable to sign or understand a power of attorney or a healthcare proxy. So there is a guardianship that one can bring under the Surrogates Court Procedure Act, the SCPA. It's called an Article 17A guardianship, and that's a guardianship that's brought for a person who has a mental disability once they're over the age of 18 to then be able to have legal authority they be appointed their what's called Article 17A guardian to be able to make those medical and financial decisions for someone who is over the age of 18 but is mentally disabled but unable to sign a power of attorney and a healthcare proxy. There's a question here, what do we do to get these documents while having to stay home during these times? That's an excellent question. In New York State, the New York State Bar Association has a power of attorney, I believe, on its website, as well as a healthcare proxy. I always recommend, and I think my colleagues, we always recommend that you use an attorney to draft the documents and to review the documents. As I said earlier, due to most of us working from home now and being compliant with Governor Cuomo's New York State pause, those many of the documents can be signed remotely and notarized remotely in order to accommodate and make sure that all the issues and documents are the issues are being addressed and the documents are being signed. So, for example, one of my brothers-in-law just emailed me this morning about a nephew of mine signing a healthcare proxy. He lives in the city. He has two roommates, and I said so he should sign his healthcare proxy, and his two roommates can act as witnesses for the power of attorney. We're going to do a videoing of the power of attorney, so I can notarize that power of attorney remotely, because I would then have seen him signing it. So again, there's a lot more. Governor Cuomo has authorized a lot more use of technology for right now while we are on New York State pause, to make sure that documents can be witnessed and notarized, and especially to make sure people have the important and necessary legal documents during this period of time. And then piggybacking on that question that was just asked, another important document, which I actually usually don't talk about with the younger, with the 18, 20 somethings, is a living will. A living will is an incredibly important document. What it is it states what your end of life wishes are. We always give our clients an opportunity to sign a living will. Not everybody does. Some people want heroic measures taken under any circumstance. But again, a living will is a document that for the most part says if a person is in a vegetative or comatose state, that they don't want heroic measures. They don't want a CPR. They don't want a ventilator. They do want maximum pain relief. These are always incredibly personal choices. Actually, a couple of years ago, I had a client who was in his mid-90s. He was very healthy, had full capacity, just in his mid-90s, hadn't done estate planning, and he didn't want to sign a living will. He's like, no, I want my kids to do everything. I want to, I want all heroic measures taken. I think a living will, again, is an incredibly personal choice and decision. And I do think it is very important to speak with the agent under your healthcare proxy as to what your end of life wishes are, as the living will is guidance to the agent under the healthcare proxy and evidence to that person of what, if you were able to make those decisions, what would those decisions be? It also is just important while families are home right now, while we're checking in on our kids who might be living with roommates in the city and not at home, and our parents or grandparents, other family members. I think these are all very good times to start having the conversation about estate planning. And again, not just for our children who are over the age of 18, but really through the different phases of life. You're having the conversations with the 30-somethings with young kids, the 50-somethings who are becoming empty nesters and looking forward to being grandparents, the 70-somethings who are starting to think about Medicaid planning. So the planning, is really incredibly important in any age. And while we're all spending so much time together, either in person or remotely via Zoom, via Skype, via WhatsApp, these conversations are much more important. And again, having the conversations about aging, what aging is going to look like, and frankly, what parenting is looking like, and how to handle these legal issues with our families and the importance of it. I think it's bringing it to the fore right now. And I can tell you, my husband and I were already married a few years. I think we had 1.5 children at the time, post 9/11. And I said to him, hey, honey, the shoemaker's children have no shoes. I said to him, at that point in time, it was really important. That what sparked our conversation to do our estate planning, which we did wills, powers of attorney, healthcare proxy, and really had long drawn out conversations as to who were to be the guardian for our children. God forbid something happened to both of us. These are not, especially in terms of choosing a guardian for your minor child or children, these are never easy conversations to have. But at this point, these are very smart conversations to have. And it's really such an opportunity to have those conversations both with kids and parents, and really to start doing your estate planning. Any other questions out there? I think I've talked at you for quite a while now. So just in terms of summing up, once our children turn 18, we know parents, guardians, um, custodians no longer have the legal authority to be able to make those financial and medical decisions. So it is important once a person turns 18 to review and sign both a power of attorney to make financial decisions as well as a healthcare proxy to make medical decisions. If we have a child who's developmentally disabled and unable to make medical and financial decisions for him or herself, but also not able to understand or sign a power of attorney and or a healthcare proxy, once that child turns 18, the parent, again, still because the child is over 18, does not have the legal authority to make those decisions. It's important to look at a surrogate's court guardianship called a 17A guardianship for a parent or loved one to become that developmentally disabled child's guardian to be able to then have the legal authority to make those medical and or financial decisions. But again, these conversations shouldn't just be for the 20-somethings as well as the 70, 80-somethings. Again, it's important to be doing planning at any age and to start those conversations. And now is as good time as ever to really start those conversations on estate planning, what that planning should look like, who should be making financial and medical decisions if you're not able to. If you have children who are under the age of 18 and God forbid something happens to you and your spouse, who should be those children's guardian. What type of planning does your planning take a look at when you get older in terms of Medicaid planning, or some of your children are married, some are not. You have a disabled child who's over. What type of provisions are you going to be making for that child? So again, I think these conversations should really start when our children are turning 18, and those conversations should be continuing through the life spectrum. And again, these decisions and conversations should be coming to the fore as part of our everyday life to make sure that we are protected in terms of our estate planning and who should be making decisions and how those decisions should be made and what our estate plan should be looking like. So I hope you enjoyed this about 28, 29 minutes of your day. I hope everybody who was participating learned something. Again, my name's Sara Meyers. I'm an attorney at the law firm of Enea, Scanlan and Sirignano. We're located in White Plains, New York, and are all working remotely during this New York State pause. We are accessible all via our email addresses. Our website is www.esslawfirm.com. Our main line is working. It's area code 914-948-1500. We are all receiving our voicemail messages via our email. Calls are being returned within the hour or two as quickly as we can. Thank you. Thank you. Someone just said it was very informative. I hope you all appreciated it. And I hope you enjoyed our time together. Thank you all very much and have a good rest of the day, and please all stay safe. Thanks. Bye-bye.